Joining me now from our bureau in Washington, D.C., constitutional attorney and associate deputy attorney general under President Reagan, Bruce Fein. Bruce, let's stipulate, of course, this is not a court of law. We'll stipulate it's impeachment, so the rules don't apply exactly yet. We can also stipulate that the framers of the Constitution would want in the impeachment process due process rights and equal protection rights for the accused. And oh, by the way, this thing called the Sixth Amendment. So as we look at the potential trial in the United States Senate, if you're the defense here for the White House, there are material witnesses that, yes, could be considered inflammatory, but necessarily have to be called in a trial for impeachment. And I would start at the top of that list, the whistleblower, and next I would put Adam Schiff, and after that I'd put Nancy Pelosi. All of these people are effectively accusing the President of the United States of impeachment. Would you agree?
Well, I think the list, in fact, should include President Zelensky of Ukraine.
Right.
After all, if we assume what's been the focus, what was the intent and motivation behind this exchange, you ought to have the principles there. And I do think that the president is entitled to counsel, even though it's not a criminal case, even in a civil case. The defendant is entitled to counsel, call witnesses, cross-examine witnesses. And I would think that the Republicans with Mitch McConnell would permit the president, who's a Republican, that due process right. I think it would be a comical not to permit the defendant to call exculpatory witnesses. I mean, that goes to the standards in Russia and China, where they have a 99% conviction rate.
I'm not worried about the Democrats, Bruce. I'm worried about the Republicans in the Senate. And I'm hearing Lindsey Graham giving signs that, well, we're not going to allow a circus in the Senate. This is not a circus. The whistleblower is a material witness to what they are accused. Wouldn't you love, as an attorney, to get the whistleblower, apparently this Eric Chamarella, on the witness stand? Wouldn't you love to get him on the witness stand? Wouldn't you love to get Adam Schiff on the witness stand?
Well, it's certainly true that the whistleblower is essential, because we don't permit faceless accusers, to participate in legal proceedings. You can't cross-examine someone who's anonymous. Right. And it just seems strange to me, having lived through Watergate, where John Dean testified he didn't have a bag over his head. He was credible and he was convincing because he was open and everyone could ask him questions, explore his motivations, what he saw. Did he have ulterior motives? And I would think certainly there's no constitutional right to make an accusation and then not appear, if your accusations are part of the prosecution's case, to testify and be cross-examined. Now, with regard to Adam Schiff or Nancy Pelosi, that becomes a more difficult question, because under the Constitution, the speech or debate clause makes it very difficult to have one member of Congress, in the performance of their official duties, called to account. This is a special privilege that members enjoy. Now, it is true that the House could discipline Schiff or Pelosi, but not likely, since the Democrats control. I don't know whether the Senate would have authority to demand that Pelosi and Schiff come and testify under the speech or debate. There's never been a precedent like that.
What we saw this week in the Judiciary Committee, the 4 law professors testifying and I understand what the Democrats are trying to do here, lay a foundation, but really it amounted to nothing more than opinion. And you can understand why, Bruce. On one hand, the White House does not want to participate in this. But on the other hand, does it bother you at all, as it does me, that the White House is not participating? Do you think this is a bit of a risk?
I think it's surely a risk. When there are allegations made and the response is either on Twitter and not immediate, it gives some credibility to the allegations. I agree with you that it's kind of odd that the law professors are really not expert in deciding impeachment questions for this reason. The framers understood it was a combination of law and politics. Is this prudential as much as legal? And these professors have no standing. They're not elected by anyone. The decision as to whether something amounts to an impeachable offense is a decision that politically accountable persons have to make. Those are the members of Congress. They can't blame it and say, well, witness so-and-so said it was impeachable, so I voted for it.
Right.
So I think it was a mistake institutionally to do that. The members themselves have to make out the case. I say it's a combination of politics and law and history, prudence, and that kind of thing. You don't have somebody go up to the Congress and says, well, this is impeachable or this is not. Remember the language of the Constitution. The House of Representatives shall have the sole power of impeachment, the sole decision-making authority. And this is another attempt, in my judgment, to escape responsibility. Totally unacceptable.
Let's look at the charges real quick, such as they are, that are being brought against the President of the United States. We're assuming abuse of power, bribery, obstruction of Congress, obstruction of justice. Let's do obstruction first. I don't understand obstruction of justice. Bruce, maybe you can explain it to me. Because if this were the case, then we're talking about a crime that the DOJ, for example, could be investigating, maybe a special prosecutor. Obstruction of Congress. The separation of powers, violating the separation of powers, is not obstruction of Congress. Bribery. Bribery, to me, if you're looking at holding a country accountable for receiving aid and conditioning the aid, then we would have to impeach retroactively all 44 previous presidents, starting with Barack Obama, who conditioned all kinds of aid during his time in the White House. And abuse of power is so vague, so subjective, so malleable, you could apply anything to abuse of power.
Well, that's true, although those terms were used in the impeachment ordeals of Mr. Nixon and Andrew Johnson about a century earlier. Now, Nixon resigned. Johnson actually was acquitted. But I agree. I have tried for now over 10 years to get accountability in the impeachment process by having the House pass a resolution in advance of knowing who's in the White House saying X, Y, and Z with specificity are impeachable offenses. There's no other system in our jurisprudence where you make up the definition of the key elements of proof on the spot. You don't write it out in advance. And the House has resisted that because they want to make impeachment whatever they think is politically appropriate and opportunistic to believe at that particular time and place. And that's simply not acceptable, and you're making a decision as critical as overturning a presidential election.
And remember, back in 1787, there was a plurality, obviously not a majority, of the framers who did not want to put impeaching of the chief executive in the United States Constitution. The reason? Exactly what we're seeing here, the political motivation, lack of evidence, but a plethora of political motivation. Bruce, thank you.
Want to see more videos like this? Click on the link below and subscribe to One America News on YouTube, and call your cable provider and kindly demand that One America News is added to your lineup. Call and subscribe today.